Good day, sir. Today we will discuss the probation, parole, and executive clemency. My name is Mark Michael Piraka, and my members are Antoinette Joy Ayarin and John Tristan Nipas, together with our advisor, Professor SJO2 Leoncho Olimioco Jr. What is probation? Probation is a privilege granted by the court to a person convicted of criminal offense to remain in the community instead of actually going to prison or jail. Ang probation ay isang privilege o opportunity na binibigay ng isang tao na hanatulan ng korte sa isang krimen na hindi makulong at pagdusahan ang kanyang hatol sa pamamagitan ng community service at iba pa. Ang akusadong nahatulan ay pwedeng mag-apply ng probation sa korte kung saan siya ay hindi na nag-appeal sa kanyang conviction at hindi disqualified dito. Ang hatol o parusa sa paggawa ng isang krimen ay laging may karampatang pagkakulong o imprisonment o pagbabayad ng fine. Ang pagkakulong ng isang kriminal ay ginawa upang protektahan ang society upang hindi siya at baguhin ang kanyang sarili para muling ibalik sa mamamayan. Next. History of probation. John Augustus, the father of probation, is recognized as the first true probation officer. Augustus was born in Woburn, Massachusetts in 1785. By 1829, he was permanently resident in Boston and the owner of successful boat-making businesses. Objectives and purpose of probation. The probation are the fundamentals of objective of a probation agency. Number 1, assist the court in matters pertaining sentencing. Number 2, promote community protection by supervising and monitoring the activities of the person on probation. 3, promote the betterment of the offender by ensuring that they receive appropriate rehabilitation services. Next, terms of offender. As use of Section 3 PD 968, Section 4 and probation and administration ambitious rules on probation methods and procedures, the following shall, unless the context otherwise requiring the constructed thus a minus rea, means friend of the court. Number 2, absconding petitioner. A convicted accused whose application of probation has been given due course of the court but fails to report the parole and probation office or cannot be located within a reasonable period of time. Absconding probationer. An accused of whose probation has granted but failed to report for supervision. Number 4, defense counsel means lawyer of the petitioner. Number 5, probationer. Probationer means a person placed on probation. Number 6, probation. It is the disposition under which the defendant, after conviction and sentence, is released subject to condition in prison by the court and to the supervision of probation officer. Number 7, investigation. The process of selection, diagnosis, and planning with the client. Number 8, supervision. The continuous process of helping the client to follow through with the plans. Number 9, probation officer. Public officers, the chief probation and parole officer, who investigates for the trial course, a referral for probation or supervise as probationer, or does both function and perform other necessary related duties, function, and directed. Next is the parole.
Parole is a process of suspending the sentence of convict after having served the minimum of his sentence without granting him pardon, prescribing term upon which the sentence shall be suspended. Ito ay binibigay sa convicted person na natapos o napagsilbihan na niya ang kalahati ng kanyang sentence. This history of parole comes from the French word parole, referring the word as in giving one's word of honor or promise. Advantages of parole. Parole is the release of a prisoner who agrees to certain conditions upon being released. An advantage of parole is that it can be used to award prisoners for good behavior during their sentence. Dito po ay, ang advantage ng parole ay binibigay ito sa convicted person na nagpakabait sa loob ng kulungan habang siya ay nakakulong. Disadvantage of parole. It involves the risk that parolee may become a repeat offender, known as recidivism in the criminal justice field. It also involves the risk that he won't in fact be able to survive on his own upon release, and will fall victim to chronic unemployment, homelessness, social maladjustment, or substance abuse. Ang disadvantage nito sa convicted person ay maaari siyang hindi makahanap ng trabaho, walang matiran, at maaari din siyang gumawa ulit ng krimen. Prisoners qualified. Unless otherwise disqualified under Section 15 of the rules, a prisoner shall be eligible for the grant of parole upon showing that he is confined in a jail prison to serve an indeterminate prison sentence, the maximum period of which exceeds 1 year, pursuant to final judgment of conviction, and that he was served the minimum period of said sentence less than good conduct time allowance earned. There is a reasonable probability that if released, he will become law-abiding. And last, his release will not be incompatible with the interest and welfare of society.
So, good day. Our topic for today is executive clemency. What is executive clemency? It's the power of the president to pardon a person convicted, and it refers to the commutation of sentence, conditional pardon, and absolute pardon may be granted by the president upon recommendation of the board. To file a petition for executive clemency, it needs to be addressed as follows: shall be submitted to the board before the said clemency will be considered. Petitions for parole shall be addressed to the chairman or executive director of the board. However, motu proprio considered cases for parole, commutation of sentence, or condition pardon of deserving prisoners wherever their interest of justice will be served hereby. Motu proprio means act taken without a formal request for another party or on his own impulsement. The prerequisites of executive clemency consists of the following: pardon,